Good day, liberators and fellow South Africans. Today is the 4th of July 2022, and the purpose of this video is essentially to give feedback to all of you who have asked us to assist you with your workplaces' mandatory COVID-19 vaccination policies in fighting them. Sadly, some of you have lost your jobs because of that, have been dismissed or retrenched, and some of you had no other option but to be coerced into taking a regular PCR test. But the short and the long is that we still believe that the whole mandatory COVID-19 vaccination policies were invalid from their beginning. But we've also given you the option that yes, you can go to the CCMA, but remember that the CCMA is a forum for settlement. It's not there, it's not part of our precedent system whereby a ruling in one CCMA case can be used in another. The adjudicators or not, the commissioners there are not obliged to follow the lead of another. I'm specifically saying this because recently there was a case that's circulating heavily on social media where this one person have successfully defended or opposed his COVID-19 policy at his workplace. But sadly, there are numerous others who say no, and each CCMA case is only for that case. It cannot be used in a court of law to say that this commissioner have given this verdict. So unfortunately, it's only limited to that case, people. So don't be fooled by anyone to say that, yeah, this is a proof that this can be done. Remember that previously there were others saying that they may make those mandatory vaccination policies, and they were even circulated in the mainstream media. And we then say, people, don't worry about that. It's not law. It cannot be, it's not part of the precedent system. It cannot be used as argument. And we immediately tell each one of you, please don't make Mexican waves about this one matter. The CCMA is only there to conciliate, mediate, and arbitrate. So it's an alternative dispute resolution process, which is by history, a arbitration process is supposed to be confidential. It may not even be distributed to other people. The content thereof can be held in privacy, etc., etc. So don't be fooled. But it's important that you keep listening to what I've got to say, because I would like to tell you where we are with your specific case. And when I say your case, we are already busy with court cases for each and every one, or that is concerning each and every one of you. And we are doing it in this way because a lot of important things happened that we had to address first before taking your individual case to court. Let me start off with showing you where the one problem started. And the one problem started, and please people, watch this video up till the end. I don't know how long it's going to be, but if you're one of those that we are assisting, it's very imperative that you watch until the end so that you understand what we are doing for you. And please don't go out and say that Liberty Fighters Network is not doing anything for you. We are. Let me show you what happened. Now, the first problem that we had to overcome, or must overcome, is the fact that from the 1st of April, the Kogta minister introduced new regulations whereby vaccinations have been introduced in our law. Now, that created a major issue because we said that the direction that they were constantly using as the law granting them the right to introduce these policies of 11th of June 2021, we said that that is not law, it's a direction. It was always a direction, and I've made previous videos about that, explaining why it cannot be considered as law. You cannot go to jail for not complying to the direction. It's merely a guidance to tell you which direction you may go. It's not law. It was never law, but they used it. And so that is a major issue that we had to address from the 1st of April. And then just before that, 2 weeks before that, there was an adverse finding in the Labour Court in Johannesburg under in the case Solidarity versus Ernest Lowe, division of Udago Trading, under case J4922. And sadly, this judgment has been also used by the pro mandatory COVID-19 policy employers to apparently confirm that they have got the right to implement these mandatory policies. And unfortunately, as you can see here, the application was dismissed. So Solidarity's application was in fact dismissed. And when you go through that judgment, there's a lot of things that one would have expected Solidarity to argue, but they never did. And eventually it was just a one-way street to confirm that yes, these vaccination policies can be implemented and employees must adhere to them. Um, Solidarity never took this matter on appeal. So I can't even say that the court was fallacious in its judgment by excluding valid arguments of Solidarity. Because the fact that Solidarity never went on to appeal this matter as one would have expected them to do. They've just accepted the judgment and left it there. And this is happening so regularly in Solidarity in AfriForum cases. And you can recall that I've said on previous occasions that I regard Solidarity and AfriForum, specifically those organizations, and any organization flowing from them to be controlled opposition. They all always pop up at cases to be the savior, and when you really truly need them, they just back down, and their whole cases are just disappearing into thin air. One would have also expected AfriForum, for example, that they are registered as an organization on United Nations level. So if they are registered in the United Nations or recognized by the United Nations as a organization, a reportable organization to them, it means that, sorry, the chances that they are captured are almost 100%. I say 100%. I'm totally convinced that they are. But in any event, now we have to overcome the Labour Court judgment as well. And when we go to the Equality Court, there's a certain argument that we had from the very beginning. And that argument had to basically adapt with the changes to incorporate the Labour Court judgment and also the new regulations that were promulgated from the 1st of April by the Minister of Cooperative Governance and Traditional Affairs, Dlamini Zuma. Now, what we did in the meantime, we decided that we have to take test cases to the Equality Court. So we have identified a few that we said, okay, we think that these are ready to argue in the right direction. And to just give you proof of that, there's the one that was issued, and then there was also this one was specifically the one under 24943 of 22 in the High Court Pretoria, Equality Court, sitting there for a business, employees at a business. And then we've also got this one 24942 of 22 that was against the University of Johannesburg for their workplace policy involving all the students as well. So those are the matters that we took to court. And there was also, sorry, before I forget, there's also another one that we are running in the Western Cape High Court. It's a bit different than a policy, but it's also discrimination involving COVID-19 policies. And then we've also got another one that we're running in the same Western Cape High Court for a doctor who was discriminated against for the doctor's belief in COVID-19. But let me just quickly say that what we had to do was that we had to attack the entire COVID-19 narrative. That was imperative that we do that. So in order to do that, we had to engage in review applications. Review applications in the High Court gives you the opportunity to ask from government to supply us with all the information that they had at the time of making the decision. So the record will then give us an indication whether they were on the right route and whether those policies that eventually came from these law that was created was legitimate. So the first one that we said we had to do was probably the most important one. It's the one to where certain it appears as if five um, vaccines were formally approved by the South African Health Products Regulatory Authority. That's the stamp proof that it has been issued. Then there was another one against the Minister of Health. This was the urgent application that we have lodged to tackle the health regulation amendments. We have subsequently also requested that our application needs to be amended to include the repeal of these regulations on the 22nd of June. And we also, something that we had to do urgently was there was another application. Yes, this is the one against the Minister of Cooperative Governance and Traditional Affairs, where we are asking her to provide us with a full record of the entire national state of disaster uh, termination. Because if we continue with getting the information which have put her in the position to terminate the national state of disaster, that information will give us a lot of power in your specific cases as well. So it is imperative for the first instance to have test cases that we're running in the Equality Court so that we can get this feeling. And then secondly, while we attending to that, we are attacking the actual COVID-19 narrative going on, get the information from the government, and then we can also utilize that in your specific case. So instead of having all of your cases at once before the Equality Court, we can then handpick or we can argue the right arguments in each one of these test cases that we are running so that it can be used in your case eventually. So we can sort out all the technicalities. And I'm not saying that if you one of them currently before court already in the Equality Court that you are guinea pigs. We have put everything that we've got, all our knowledge and our expertise that we've got into those cases. So it's not that your case has been have been put to either be unsuccessful or not. We have compiled your cases to be successful so that we can use your cases at the end of the day and your success that we believe you're going to have at the end of the day in all the other cases. You do not have to be worried that your claim is going to prescribe because you've literally got 3 years from the date when the termination or the termination or the retrenchment happened up till for 3 years from there, you've got time to put in your cases and for us to do that for you. And we're not saying that we're going to wait for 3 years and just a week before the time we're going to put your case there. We are going to lodge your application as quickly as possible. We've already got direction hearing dates for two of these cases that we are running in the Equality Court. Meaning that within literally a month or two from there, we will have our formal hearing and finalize it, and then soon thereafter, hopefully soon thereafter, the judge is going to make his or her judgment in that particular case to work on. So your case, yes, everyone, you've lost your job, you only had a few bucks left to buy groceries, and we know that it's difficult to get a new job. However, some of you were blessed to get a better job after you've left your infamous employer who have made these policies, and many of you have told us that you are actually in a much better position than you were while you were with that employer. But unfortunately, it's not the case with all of you. And we do understand and we do have a lot of sympathy in your matter. But instead of having taken your case and then suddenly there's all these technicalities popping up, we had to argue the right arguments to bypass the Labour Court judgment that's there sitting as a cancer all the time. And then we've also got the legitimacy of the health regulations that's still a major issue. We had to fight against all of them. We had, and you are, we're running those cases as Liberty Fighters Network for our members and in the interest of the public. So you are part of that. It's your case. So you can already tell everyone that you've got all these cases already going on in your favor. So, people, there's so many issues that we would like to discuss with you, but it's so important that you don't come to a conclusion that Liberty Fighters Network is just big mouth and we're not fighting for you. That's not the case. And I hope that I have given you a lot of information to realize that what we are doing is to fight for you still, individually and as a group, and for the South African people. It's not only to benefit some people out there, it's for all of you. So thank you very much for your support. Remember to subscribe to our channel. Also consider becoming a member. Our membership will change a lot within the next couple of weeks to specifically make provision to give workshops, to give valid information how to become your own lawyer at the end of the day, so that all these issues that you want us to sort out for you, you can be empowered to eventually sort it out for yourself. So it's very important that you watch our channel, consider becoming a member of our channel so that you can get all these additional workshops, the info regarding how our legal system works, everything making law, etc., that we would like to share with you. And thank you very much for your ongoing support and have a blessed day. God bless each and every one of you.